Hello everyone, I'm Steve Humphreys from Clover Risk Funding and this is our podcast In Clover. At Clover, we do things differently. We provide a premium one-stop funding service to the insolvency profession that leans on our experience in the industry to deliver bespoke solutions that meet the unique needs of our clients and their lawyers. In short, we offer experience with an edge. Today I'm here with Hannah Griffiths, who's a partner and head of restructuring and insolvency at Pinsent Masons, for what I'm calling our Christmas edition of the podcast. In this edition, we're going to talk about Hannah's journey in the world of insolvency, some key tips for practitioners when it comes to litigation funding from a lawyer's perspective. We'll have a look at some emerging trends in funding for 2023 and 2024 and talk about some recent case developments. So for listeners who do not know Hannah is a 16-year veteran in the insolvency industry, worked with some of the most prominent insolvency practitioners and on some of the most prominent insolvency matters, particularly in New South Wales over that time. Most recently, Hannah took up the role as the head of restructuring and insolvency at international firm Pinsent Masons. Firstly, Hannah, welcome to the podcast.
Thank you, Stephen.
Let's start at the beginning because this always fascinates me. I like to understand people's stories and how they ended up working in insolvency. So how did you get your start in insolvency? Where did it begin?
So it probably started relatively early in that 16-year chapter. I started working in debt recovery as a paralegal and then quickly developed a bit of a niche for a large telecommunications provider in Australia and headed up the debt recovery practice, which had a lot of insolvency elements to it in terms of winding up companies and bankrupting individuals in respect of outstanding debts. And that quickly developed into running more substantive litigation when I became an admitted solicitor in the insolvency space. And really over that period, I've worked in a variety of private law firms. I've worked in-house in a complex dispute resolution team for a large bank and back into private practice in the last 10 or so years. So I would say I fell into insolvency a little bit, like it found me, and I've really doubled down and become a specialist in the space because I really love the combination of complex law and also the financial element and the commercial side of generating solutions for insolvency practitioners and bringing about returns.
It's a funny thing, isn't it? I don't think anyone that I talk to, either on the podcast or when I'm out and about in the insolvency world, went to uni wanting to be in insolvency. It's something we just all fell into and then we all love and we all stay.
Yes.
It's completely bizarre. I can't think of any other industry like it, to be honest. Now, you've just moved to a new firm. Tell us a bit about that. What's going to be the focus and how's the team looking? Just tell us a bit about that move.
Yeah, sure. It's a super exciting move for me and my team. We had built a team at an earlier firm, a national law firm, and I'm really excited to take the development of the practice on to a global scale and work with my international restructuring and insolvency partners on cross-border matters. The firm, Pinsent Masons, is committed to developing and expanding its business in the Asia-Pacific region. And so I've been brought on board to launch the practice in Australia in that practice area and grow the practice and also service the full life cycle of their business clients' needs. Particularly, they are seeing in their supply chains a higher degree of insolvency, which they're looking at generating solutions for their clients managing those examples of financial distress.
Excellent. So we obviously have worked together on many litigation funding matters back in my previous role with the government and in your other previous roles. So we've been on funded matters together, and I know that you develop a close relationship not only with the practitioner but with the funder. What would your top tips be from an insolvency lawyer's perspective be for practitioners or anyone else thinking about getting litigation funding?
Yeah, sure. There's probably a few key elements to that. Firstly, seek funding assistance early. So identify the need for funding early. Like the appointee will have an idea of how much money is immediately available to them in their appointment, and they'll prioritise that based on what they need to achieve to bring about returns for creditors. But in my experience, a funder is much more receptive on assessing and funding prospective investigations and claims if those claims that assistance is sought early and not on the doorstep of, for example, like a limitation period expiry or when litigation is well advanced.
Yeah, I think I'm going to double down on that and say from my perspective as a funder, I hate it when it comes to me late. I think, and part of the problem with that is not just the claims gone stale. To me, it's, well, the recovery's going to have gone stale. If a practitioner's been in a job for 3 years, the targets generally have had an opportunity to move money around. They've had an opportunity to strengthen their position, and just the general effluxion of time makes it more difficult.
Correct.
To run the case. When you're talking to practitioners around funding and how to get funding, one of the interesting areas is to do a public examination or not. Do you have any strong views on that?
I don't have strong views, but I think there are some considerations for IPs when assessing whether or not there's merit to a PE. It's obviously a very useful tool for an insolvency practitioner. It's inquisitorial in nature. It provides an open window or plethora of opportunity to explore lines of inquiry, gather evidence, test defences. And so for that reason, it's a really useful tool in an insolvency practitioner's toolkit. It can fill evidentiary gaps and test the defences sufficiently enough that a funder may obtain more comfort around the viability of a claim. It also is relevant to consider the nature and extent and scope of the claims, because they may be useful, but they're not necessary with some types of claims. So, for example, you may have like a bundle of unfair preference claims, which holistically you may want to run as a mothership type proceeding, but you've already got really detailed records on the credit management system to adequately assess the defences that might be run against you. So, are you necessarily going to do a PE? Maybe not, but certainly that's a discussion piece. I think that's a relationship piece and a discussion piece with the funder and the insolvency practitioner. Is there enough on the table in terms of evidence to run this prospective litigation successfully, or do we need to plug some gaps, or would the litigation funder be more comforted with testing some of these defences indicatively out? I think it would be dangerous to suggest that PEs are necessary always, because I think some people get a little bit carried away with PEs and they're not necessarily meritorious.
And leading on to that, obviously I get to see a lot of funding briefs and I frankly can say that the standard of them runs from frankly piss poor to very, very good. And the briefs that I receive from you, I'll give you a wrap here, are generally very, very good. What do you see as essential in going into a brief to a funder, and what is the essential information that you need from a practitioner to build that brief? Yeah,
so in my experience, like the quality of the brief that's put together is directly related to or correlates with the receptiveness to prospective funding and indeed the success of funding, both at an investigative level and substantive proceedings. Litigation briefs that are issued by my team usually include an outline of what the claims are, like in terms of the sections of legislation where the claims will be brought, the value of those claims, the targets of those claims. You'll also consider the estimate of running the claims in a phased way, including contingencies, because I know in my experience funders do not like intently when things run off kilter, and they can because it's litigation. So I normally put in a range of expected contingencies which sit outside the main phases of work in terms of running litigation. and also adequately scope the professional costs of both solicitor, of counsel, the disbursements that are required in terms of transcript fees, hearing fees, service fees, photocopying fees when you're having to compile large bundles. All of these things are relevant for a funder to consider and an insolvency practitioner when looking at matters of proportionality and commerciality of funding. And the other key thing too is an insolvency practitioner is often having to invest a large amount of time when they're running litigation. And so depending on the size and scale of the job, it may be warranted to include, for example, a line item along the phasing of the liquidator's remuneration to conduct the litigation, which in my experience, subject to the scale and also the reasonableness, is more than appropriate to include.
Oh, I think it's actually something that's essential to include. I know on a number of matters that I've looked at, particularly recently, I've gone back and said, look, this is going to be big. I don't really want the practitioner floating out there building up a whip balance that because sometimes those whip balances make the settlement of a claim 2 years down the track much more difficult. If the practitioner's had a building whip balance and there hasn't been some form of funds going in to bring things along, that can make the settlement difficult as time goes on. One of the things that I think was really interesting that you said was talking about the investment of time of the practitioner, not the lawyer, but the practitioner, and I think it is something that we regularly miss. Certainly, with my funding hat on, just how much time it takes for practitioners out of their business to run a piece of litigation. And when you think some of these practitioners that we're working with regularly have 50 to 100 files on the go, taking them out to work on one piece of litigation can be quite expensive.
That's right.
So it is certainly something that we like to focus on at Clover is how can we help the practitioner as well. One of the things that I know you get asked a lot, and certainly as a funder, I get asked it all the time, is about the approval process for litigation funding. It surprises me all the time when I get asked about it, and it surprises me. It doesn't surprise me when creditors ask me, but it certainly surprises me sometimes when practitioners ask me, well, how should I go about getting it approved, and are you going to fund me for getting the approval? I thought it would be useful for you to give our listeners a high-level précis of the process of getting approval and your thoughts on the options that are available for practitioners to take to get the funding approved, because obviously it's great to have a funder want to give you funding, but it's a complete waste of time if you can't use it.
Yeah, that's absolutely correct. So there is a section in the Corporations Act, the 4772B approval process, which is widely known by most insolvency practitioners as requiring permission of creditors or the holy water blessing of the court to sanction the entry into an agreement that will extend beyond the statutory period. And so appointees and their approach to how they obtain approval differs depending upon the circumstances of their appointment. So I'll run through that. If the creditor body contains a large amount of related party creditors and some of the targets of the prospective investigations and indeed the subsequent litigation are in that body of related party creditors, my experience would suggest that the preference of the appointee to avoid an awkward meeting of creditors, which includes those related parties, and indeed gives them the heads up effectively that they are likely to be pursued because the details of why a funding deed or an engagement of lawyers is required will alert them to the prospective claims. If there is a large body of related party creditors, they'll often prefer to go off to court and obtain the approval ex parte behind closed doors with no obligations to disclose the contents of the deed or what they're going to investigate or the nature of the claims. And usually appointees will obtain confidentiality orders as part of that process, right? So there is no basis upon disclosure of the scope of the funding, what they're looking at all in terms of creditor requests. And I think that's really important. If there is not related party creditors, and there is in fact just claims to investigate, and they might be direct claims against the directors, for example, which are probably a bit more routine in what would be assessed. There's likely to be a large body of creditors that probably want the directors investigated for those claims and would readily vote in favour of the funding approval to be approved at a meeting of creditors without much controversy. I've certainly sat on quite a few of those creditors' meetings in the event that there may be issues that emerge or questions that are sought of the appointee from creditors. And I'm pleased to report that in the main, there is limited conjecture on funding because creditors are pleased to hear that investigations are happening and claims are going to be pursued, because ultimately, at the end of the day, that's what the appointee is doing, trying to bring about a return for the external administration, which could see those creditors paid a dividend larger than what they're otherwise entitled to.
I think it's a process that I'd like to see when a funding application comes to me, the practitioner already thinking about. Sometimes I certainly see on files where we send out a term sheet and say you're on, you're ready for funding. It's at that point that the practitioner starts to think about, how am I going to get this approved? From my perspective, looking at approvals, that sometimes you then have a 3-month lag where everyone was gung-ho and ready to go, and then suddenly we're in the approval process. And so I would be saying a tip from me would be, let's start thinking about approval while we're talking about funding, because it's going to be necessary if you get funding, but it's probably also going to be necessary to report to the body of creditors that you haven't got funding. So having a report ready to go that's either we got funding or we didn't get funding, I think is a really important thing.
I agree.
Turning now to some developments over the course of the last year in litigation funding. Certainly, it seems to me that we've been through a period where funders are looking for new methods to fund. They're looking for new things to fund. One of the things that certainly is across our radar at Clover is funding before liquidation. So funding either when the company's in voluntary administration or under a deed of company arrangement. That seems to me to be a real emerging trend. Do you have any thoughts on seeking funding and the use of funding in that voluntary administration and deed of company arrangement space?
Yeah, I think that is certainly an emerging trend. I think if I was to speak colloquially or like generally about director or shareholder actions prior to an appointment or as an adjunct to an external administration process, I think there is generally a lower appetite commercially to fund matters of that nature. I think because the risk profile is much more variable and far less certain, and because it can be a high stakes game or high stakes, high reward type of funding, it requires the right combination of a legal team and funder to for that to be successful on both fronts. I wouldn't say it's something that it's certainly an emerging appetite on the right matter, but I don't think it would open the floodgates to general commercial litigation outside what we see as shareholder class actions, which obviously are a very different type of pre-insolvency or adjunct insolvency litigation.
Yeah, I'd certainly agree with that. I think they're hard to fund. I think there is. We've certainly looked at a number of cases in this area over the course of the 8 months we've been in operation. They're difficult to fund from a loss perspective at times. You can certainly see that there are people with deep pockets who you potentially get a recovery from, but what's the loss and how does the loss construct? And to be honest, I think one of the joys of being an insolvency litigation funder is the person that you're funding knows about litigation, knows about the process, knows about the risks, whereas having directors and potentially shareholders come to you who are probably much less litigious, that there's a much more of an education process that's required with them. We've also obviously seen, particularly in the construction space, the rise in construction failures, and allied to that, claims that arise under the various security of payment legislation, arising and probably needing, because of some case law, those entities to be the subject of a deed of company arrangement. What are your thoughts on that process, and particularly the differences between doing a holding docker and just a general deed?
Yeah, I think it's really interesting, that concept of, well, first of all, preserving SOPA claims, utilising a docker, or having a holding docker to operate as maintaining the status quo whilst you're assessing the broader external administration. I think it is a really interesting idea to provide more optionality. I mean, I've heard of a matter or two that where the funder has in fact been the deed proponent on a docker. It may have been one of yours.
Well, yes, and I should declare for our listeners that wasn't intended to be a Dorothy Dixer, but I'll step in. Yeah, look, I think it's really interesting, the notion of protecting SOPA claims, protecting value. You know, the security of payment legislation is designed to be an interim process. It's designed to put money in the hands where it should be in construction. And I think doing things within a deed of company arrangement construct that reduces the chance of the deed being set aside and reduces the chance of there being problems down the track can only reduce the risk profile of these things for a funder. So we had a matter that came to us originally as a holding docker. Originally, we do all the things that are necessary to get the approval of a holding deed to allow for the litigation to be both preserved and run. And I can't take claim to the strategy of Clover eventually becoming the proponent of the deed. That was the brainchild of one of the lawyers on the file. But the minute he said it to me, it made sense, because you end up in a scenario where, in that particular file, you end up in a scenario where the opponent in the litigation is also a creditor, so they're involved in the meeting process. As often happens in these construction files, the bondholder, who potentially has a claim to some of the money, is in the meeting, and they have the opportunity to vote and they have the opportunity to participate, which is great, because if there is an eventual attempt to challenge the deed, you can go up to court and say, well, Your Honour, they had a chance. They were in the meeting. Either they voted against it and that was their say, but they lost, or they voted for it because they also want this litigation resolved. It certainly has given, in the file that we're talking about, the practitioner a lot of flexibility. And it certainly meant that in the end, we haven't needed to do much with the litigation, because it's become a proof adjudication process rather than a litigation process. So I certainly think, from my perspective, we're going to see more of that.
Yeah.
More construction, unless and until the SOPA regimes are amended, or there's a High Court case that talks to this issue of, do security of payment claims survive into a liquidation? We're going to need to do that, because the figures around construction failures are still massive.
That's right. And the Supreme Court, certainly in New South Wales, in the case of Kennedy Civil Contracting, actually looked at this very question and said that a docker was a legitimate way to preserve their SOPA claims. So this very point has already been looked at least at the New South Wales Supreme Court level, and I'm sure we'll see more of it.
I think we have to. I think as more construction companies fail, you're going to lead. It's the only way you're going to extract value. If we move more generally then into recent developments in insolvency law, 2023, I nearly said 2013 then, geez. 2023 seems to have ended with a flurry of interesting decisions in the insolvency law space. We're starting to gaze forward to 2024. What are the cases that have come out recently, or case that has come out recently, that you think insolvency practitioners should take most note of as we move into the new year?
Yeah, sure. One of the ones that I thought was quite interesting was the case of Sino Group International and Jimbaroo. So that was a full court of the federal court decision a few months ago. And that was really drilling into the creditors' reports in the context of dockers and looking at the analysis provided by the appointee in respect of, to creditors, on voting on the proposal. And ultimately in this matter, the court concluded that the report was misleading and set aside the DOCA. But I think for practitioners, it's really important to ensure that all of the analysis which is conducted is embedded into the report, albeit it might be contained in an appendix and a summary is provided in the body. But one of the things particularly drilled into in this case by the judges reviewing the report was the absence of the high-low analysis on the comparative DOCA v liquidation scenario. And so I think that's just a really important point. We all know, and I mean, I advise insolvency practitioners all the time, including reviewing and settling creditors' reports, particularly when there's contentious elements that might be contained in it. I understand the really narrow window of time that practitioners are forced to complete these statutory reports. But I think it's really important to take practice points like that from the court and embed that into the review process of preparation of reports. It's an easy win in terms of ticking that box, ensuring that the high-low comparative analysis is done, just so that everyone is on the same page and there can't be an allegation of because I'm sure it was not the practitioner's intention to mislead creditors. It was just that in the court's opinion, when the argument was run, that there was a gap in the detail provided. So that was an interesting case. The other one, which was a bit earlier in the year, but I think is very significant and is still doing the rounds with in correspondence and litigation, is the applicability of set-off. So the metal manufacturers Morton case, which I think you were aware of as well earlier in the year, the first High Court decision of the year, number one, but just dealing with the concept of mutuality and the applicability of set-off. So at the heart of that case is really this concept of mutual debts and dealings, and do they arise from the same circumstances. So that's at the heart of that decision. It's still an interesting legal piece where I think a lot of people are still not really they're suggesting that there's mutuality, but when you look at the application in having regard to that case, there isn't. Yep. There isn't. And there's a real distinction there, like, are the mutual debts and dealings arising as between the company and the third party, or are these debts and dealings arising between the liquidator wearing their new hat and the third party? And I think there's still some confusion there because they're not under one big umbrella. They have a different role.
Yeah, and I think when you look at the judgment in MJ Woodman, it's made pretty clear, that the starting point for a lot of our talking about mutuality and set off was Reed Parker. Reed Parker was wrong. That cascaded through into a plethora of cases where that exact point that you're talking about, is it a liquidator with a new hat and a third party, or the company pre-appointment and a new party? To me, I struggle with the notion that people are getting confused with that because I think the High Court was pretty clear. I actually thought people would be more confused about the other big High Court decision from the start of the year, which was Badenoch. But I do find it interesting that practitioners are still getting correspondence. We're still talking about mutuality. Yes. When the High Court very much seemed to slam the door on it.
That's what I agree. It's an interesting.
But it does go to, one of the very interesting things, and probably one of the reasons, to get back to where we started, insolvency is interesting because, the law's not perfect. We're going through a process now, and somewhere listening to this, John Winter will be screaming root and branch, probably in his car, where reform to insolvency law is coming. I'm going to ask a question without notice here. If you held the pen for the drafting of the new laws, what is the one thing you would change, or one thing that you would double down on? Why?
I think the key thing that frustrates me almost, like with every alternate job that I receive, is dealing with insolvent trusts or corporate trustees, dealing with that issue. And I really think that needs to be embedded in the legislation because it just creates a level of practical chaos trying to deal with insolvent trusts or corporate trustees. That would be my magic if I had the pen. That would be the first thing off the list.
Excellent. That's interesting, and you're not the first person to say that to me. I tend to ask that question a lot, and I tend to get almost the same answer.
Well, I'm glad I'm the popular selection on that.
No, look, I think what interests me is I probably, as a funder, I have a slightly different view, because I'd like practitioners to get paid more. And I know that's not popular. It's popular with practitioners who are listening, and it's popular with lawyers. But I know it's not popular with the populace. I like practitioners to get paid more. Anything that we could write into the laws that led to a situation where practitioners get paid earlier and get paid more would be something that I would write in tomorrow.
And recognises also the personal risks that they take on in performing their professional role or statutory function.
Well, the reason I have a job, quite frankly, is because practitioners don't get paid. And, that startles me. And I'm not saying that there should be a scenario where I'm law reformed out of a job, but I just like it to be a little bit easier for practitioners to get paid.
Well, that would be nice. I'd welcome that too.
All right, we're gonna jump off insolvency now, albeit it's kind of related. I mean, one of the things I say all the time to people is that working in the insolvency industry is bloody hard work. Mm-hmm. It's tough. You're involved often with the third or fourth worst thing that's going to happen in someone's life, outside of a bereavement or an injury. A business failure for a director, for a shareholder, for an employee is terrible. Maintenance of balance and good mental health is obviously vital for insolvency practitioners. And one of the things that's always fascinated me about you is your long-standing role with the Rural Fire Service of New South Wales. Can you tell us a little bit more about that? What do you do with the RFS, and how important is it to you as a senior practitioner in the insolvency world to have those things outside of work to get you away from your day-to-day?
Yeah, sure. So I've actually been a volunteer firefighter for over 20 years now, which is it's been an amazing interest area of mine, contributing to my local community where I grew up, which was Golston, in the Hornsby-Ku-ring-gai district. I undertook a lot of training and was one of the first female firefighters trained in wearing compressed breathing apparatus, so capable of running into burning buildings and underdoing structural firefighting. And that surprised a lot of people. They're like, you're a female doing this. And I always used to say, I can do the same things, I just have to do things a bit differently or smarter. So really proud of that achievement. Then I was elevated and voted by my peers to a deputy captain role, which I served for a couple of years. I had a few children after that, so I was in and out of service with the RFS, but I've led deployments interstate, into Victoria, into northern New South Wales, western New South Wales, and that was super enjoyable, doing a whole range of bushfire, grass fire type deployments in Section 44s or state of emergencies. After that, I moved down to Canberra for a period of time and was down there. I wasn't an active member for a brief stint, and then when I moved back to Sydney, I joined the Warringah Pittwater district. Now serve at another brigade, Beacon Hill, and I'm back on the tools, as it were, as a firefighter, flying under the radar, doing just general duties. But yeah, I've had a great experience with the RFS. It's been a really amazing place to meet a whole range of different people from diverse backgrounds, different ages, different skill sets in terms of their vocational what they choose to do as a vocation, and bizarrely enough, also attracted work as a result of being in the community, although that was never the purpose. It was for me to contribute back to the community and do something practical. And I love the difference between, my intellectual pursuits as a lawyer and the practical pursuit doing that sort of community work. So that's a little bit about
Wonderful.
The RFS.
It's very interesting. As I said, it's always fascinated me, and I'm very much fascinated by the things that people I talk to do outside of work, because I think it is so important to have those extra things. I've got one last question. You mentioned your boys. They're avid rugby players. This is one that you might choose not to answer, but I know we've all just had the Wallabies disaster at the World Cup.
Yes.
So finally, has Eddie Jones destroyed Australian rugby?
Oh, look, controversial topic. I would hate to speak against him. I certainly, I think I asked I've got 3 boys, and my 11-year-old aspires to be a future Wallaby. And I said, how does that make you feel about Australia's performance in the World Cup? And I think he summed it up quite beautifully. He said, not good enough, Mum. I think they made too many changes too late to the campaign. And I said, I think you might be onto something there.
Yeah,
maybe we should give some feedback to Eddie.
He's very smart, your boy. Look, thank you so much for joining us on our Christmas episode of In Clover. It's been insightful and interesting, as it always is, to talk to you. So thank you very much.
You're welcome.
For all of our listeners, obviously, please subscribe, like, and review on your favourite podcast platform. We're on them all. And if you have any questions you'd like us to answer on the next podcast, please reach out to us via our website, www.cloverriskfunding.com. Thanks very much.